Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. I am, of course, Attorney Andrew Branca for the Law of Self-Defense. Thank you. Thank you very, very much. Greatly appreciated. And today we are gathered to talk about Hawaii, the lovely state of Hawaii. I've actually never been. Hawaii and Alaska are the only two states I've never been to. One of these days, I'll have to fix that. But the lovely state of Hawaii, which has essentially just told the U.S. Supreme Court to piss off. We don't like your laws here. Your laws, in particular, your jurisprudence around the Second Amendment. We're Hawaii. We have our own history and tradition. The law applies differently to us than it does to the other 49 American states and the District of Columbia. So no. We rebel. We're in insurrection against the Supreme Court of the United States when it comes to the Second Amendment. So they released, the Hawaii Supreme Court released a decision in that respect just a couple days ago. And we are going to do a reading and legal analysis. Now, most of the snazzy comments here are going to come most of the insightful comments, I should say, are going to come not so much from me. I don't claim a great degree of Second Amendment legal expertise. That's not really my area of the law. But from my good friend, Kostas Moros. Attorney Kostas Moros does a great deal of Second Amendment litigation out of California and also works on cases all over the country. And of course, right now, following Bruen, we have a ton of Second Amendment suits going through the federal courts because there's so many states and lower level federal courts that are in open rebellion against the Supreme Court on their Second Amendment jurisprudence. They have been for years, ever since Heller. But now Bruen, by requiring that any rule infringing the Second Amendment must be based on a historical tradition of American infringement on the Second Amendment, as understood by the founders, effectively threatens virtually every gun control law we have in the books. Licensing, FFLs, machine gun restrictions, everything, concealed carry licenses. There's no history and tradition for any of that in American law. So, of course, the gun control fascists are freaking out. They see their whole house of gun control cards about to collapse. And so they're turning into word salad babbling legal idiots, as evidenced by the Hawaii Supreme Court. So what I've done is Kostas had done a Twitter thread on this, and I've embedded his tweets in my version of Hawaii's U.S. Supreme Court decision. So it's obviously him providing these insights. I don't want to be perceived as stealing his thunder. I told him I would be doing this. He's been on the show before, by the way, as a guest. Great guy, great lawyer, great patriot. So that's what we will be doing today, reading through that opinion with Moros's Twitter comments embedded in the document. And I think it'll be a good time. So with that out of the way, let's go ahead and start the formal launch of today's show. Here we go. All right, and today's show is brought to us by our sponsor, CCW Safe, a provider of self-defense legal services, what many people mistakenly call self-defense insurance. If you're involved in a use of force event, they're committed to providing you, if you're one of their members, with funds and resources to cover your legal expenses and much, much more. There are a number of companies that offer this kind of service out in the marketplace. This is the one I'm a member of. CCW Safe is the one I trust. My wife is also a member of CCW Safe. And there are others I simply can't recommend at all. So if you'd like to learn why I trust CCW Safe, you can go to lawofselfdefense.com/trust, lawofselfdefense.com/trust. And I have a very short 2 or 3 minute video there where I explain what I find most advantageous about CCW Safe, why I trust them. And there's a discount code there. You can get 10% off your membership at CCW Safe when you decide to become a member. Again, learn more at lawofselfdefense.com/trust. All right. So let's get into Hawaii. Make sure. Let's see. All right. Oh, someone's talking about me going to Japan. I've been to Japan. I've never ridden a motorcycle in Japan, but it's on my bucket list for a motorcycle tour for sure. All right. So let's make this a bit bigger. So this decision was brought to my attention when I saw this tweet from Kostas a day or two ago. He writes, the Hawaii Supreme Court released a ruling that sounds like every town for gun safety, a gun control organization, wrote it for them. They're funded by Bloomberg, the former New York City mayor, who's all in on gun control. Moros, calling him Moros, Kostas. Kostas writes, they say Heller was wrongly decided. Like that's up to them. And talk about the historical tradition of the former Kingdom of Hawaii, as if that is at all relevant. A lowlights thread. So he had a thread of a bunch of Twitter comments on this decision, and I've just embedded them in my version of the opinion from the Hawaii Supreme Court, where they were relevant. So what do we have? We have in the Supreme Court of the state of Hawaii, Hawaii versus Christopher Wilson. February 7th, 2024, so 2 days ago, this was published. There goes the fire trucks. It's snowing here again. Let's see. Article 1, so Section 1 of this opinion. Article 1, Section 17 of the Hawaii Constitution mirrors the Second Amendment to the United States. We read those words differently than the current United States Supreme Court. You see how they put that? The current United States Supreme Court. It's not just the Supreme Court. Does this suggest that they're hoping for a different United States Supreme Court in the future? One where the balance has shifted to the progressive left and they're getting different Second Amendment jurisprudence out of the Supreme Court? We don't like this current U.S. Supreme Court jurisprudence on the Second Amendment. They continue. We hold that in Hawaii, there is no state constitutional right to carry a firearm in public. So right there, they're on the wrong track. Why? Because the U.S. Supreme Court has said there is a federal constitutional right to carry a firearm in public, and that is incorporated to the states, regardless of what the state rule may be. The decision continues. The state appeals an order dismissing 2 place to keep offenses for pistol or revolver and ammunition filed against defendant Christopher Wilson, citing New York State Rifle and Pistol Association versus Bruen, U.S. Supreme Court, 597 U.S. 1, 2022. The Circuit Court of the Second Circuit dismissed the charges. So the trial court was faced with this defendant who was charged with essentially an unlawful possession in public, unlawful possession of a firearm in public charge. In other words, bearing arms in public charge. And the defendant said, no, under Bruen, I have a constitutional right to do that. And the trial court said, you know what, you're right. And I dismissed that charge. And the state didn't like that. The state appealed all the way up to the Hawaii Supreme Court. The state challenges Wilson's standing. Does he even have a legal privilege to contest this fight? The state says Wilson did not bother to apply for a carry license, which we'll see Hawaii makes effectively impossible, and thereby failed to satisfy Hawaii's license to carry laws. And Kostas note that this quote-unquote crime occurred pre-Bruen, when Hawaii had never issued any permit to anyone. So it's insane. The state gets to argue he should have applied for a CCW permit. Now, Kostas corrects himself. It turns out that Hawaii had issued permits, but only 4 of them over a 20-year period. So he quickly corrects himself. Small correction. Apparently, Hawaii issued 4 permits statewide over 20 years ago. But Maui, the particular island where the facts of this case happened, had never issued a concealed carry permit. Felt I should correct myself, but the point stands. An application in 2017, an application for a concealed carry permit to the Maui Police Department would have been futile. And futility is a defense, folks, a legal defense. Continuing with the opinion, so the state argues that Wilson cannot bring a Bruen-based constitutional challenge to the concealed carry law. Wilson, the defendant, believes otherwise. He says the concealed carry laws subvert his new constitutional right to protect himself in public by carrying a lethal weapon. Hawaii's place to keep laws, so these are where you can bear a gun laws. Hawaii's place to keep laws violate the Second Amendment to the Constitution and its counterpart, Article 1, Section 17 of the Hawaii Constitution, according to the defendant. Because the state charged Wilson with place to keep offenses, we conclude that Wilson has standing to challenge the constitutionality of those laws. A criminal defendant has standing to level a constitutional attack against the charged crime. Wilson, though, lacks standing to confront the license to carry law. The state does not charge him with violating the license to carry law, and Wilson made no attempt to obtain a carry license, which in Maui had never been issued. We reject Wilson's constitutional challenges. It'll be interesting to hear why. Conventional interpretive modalities and Hawaii's historical tradition of firearm regulation rule out an individual right to keep and bear arms under the Hawaii Constitution. In Hawaii, there is no state constitutional right to carry a firearm in public. So again, obviously already on the wrong track. Bruen said the American history and tradition of gun control. Before 1950, when Hawaii became a state, it was not America. And when Hawaii became a state, they were obliged by the U.S. to ditch any of their laws or practices that were inconsistent with American law at the time. Obviously, we're not going to allow a state to bring with it laws and history and tradition and practices that are inconsistent with being one of the United States. By the way, some of the history and practices of Hawaii, cannibalism, you think that we were going to let them keep that? Capital punishment for women who ate with men, you think we were going to let them keep that? So obviously, Hawaii's history and tradition, to the extent it's different than that of America, would be irrelevant under the Bruen analysis. But it's what this court hides behind. Bruen snubs federalism principles. So this is interesting. So, of course, the doctrine of federalism is that the states have some powers and the federal government has some powers. Now, the established American law is that before the 13th, 14th, and 15th Amendments passed after the Civil War, obviously there were some states that thought they had the power to completely leave the Union, the Confederacy, and we fought a civil war over it, and they lost. So we can compel the states to stay in the Union by right of conquest. And then we passed the 13th, 14th, and 15th Amendments that did a variety of things, but one of those things is it imposed upon the states the constraints of the Bill of Rights. So it constrained states' rights. And that's what the law actually is. So Hawaii doesn't get to go back to a pre-1865 view of American law. It doesn't have that privilege. Bruen snubs federalism principles. Still, the United States Supreme Court does not strip states of all sovereignty to pass traditional police power laws designed to protect people. Wilson has standing to challenge these gun control laws, but those laws do not violate his federal constitutional rights. Who would define whether or not Hawaii's gun control laws violate his federal constitutional rights? The Hawaii Supreme Court or the United States Supreme Court? I would suggest it's the latter. Subsection 2A, charges and alleged facts. In December 2017, the County of Maui Department of the Prosecuting Attorney charged Christopher Wilson by felony information. He had violated a statute governing the place to keep a firearm, another the place to keep ammunition, another a permit to acquire ownership of a firearm, and first-degree criminal trespass. The facts are slim. Yep, we're going to assert felony charges and say he doesn't have the constitutional rights the U.S. Supreme Court says he has on slim facts. Interesting. Declarations and police reports submitted to support the party's position for the motion to dismiss comprise the factual record. In December 2017, at about 11 p.m., flying Hawaiian zipline owner Dwayne Ting saw men on his fenced-in property via video surveillance. Ting reported the matter to the Maui Police Department. Officers headed to Ting's property. Meanwhile, Ting, driving an all-terrain vehicle, corralled Wilson and his 3 companions. Armed with an AR-15 assault rifle, he detained them until the police arrived. Then Wilson volunteered to the officers, "I have a weapon in my front waistband." The police lifted his shirt. Wilson had a Phoenix Arms .22 long rifle caliber pistol loaded with 10 rounds of .22 caliber ammunition. A records check reported that the pistol was unregistered in Hawaii, and Wilson had not obtained or applied for a permit to own a handgun. Wilson told the police that he legally bought the gun in Florida in 2013. Now, folks, does America have a history and tradition from 1791 to the early 1800s of registering firearms or permits to own a firearm? No. So these laws themselves are highly constitutionally suspect. Wilson's motions to dismiss, subsection B. In May 2021, Wilson moved to dismiss counts 1 and 2, citing District of Columbia v. Heller and McDonald v. City of Chicago. Wilson argued that prosecuting him for possessing a firearm for self-defense purposes outside his home violated his right to bear arms under the Second Amendment to the Constitution and Article 1, Section 17 of the Hawaii Constitution. The state opposed the motion. It presented records from Florida and the Department of Justice Bureau of Alcohol, Tobacco, Firearms, and Explosives to refute Wilson's remark about when and where he purchased the gun. The record showed Wilson had not applied for or been issued a concealed weapon or firearm license pursuant to Florida laws, which is not required to purchase a firearm in Florida, by the way, folks. And 2, in April 2011, someone not named Christopher Wilson purchased the pistol from a licensed firearms dealer in Florida. Well, private individuals are allowed to sell guns to each other, folks, within the same state. The circuit court denied Wilson's motion to dismiss in July 2021. It relied on Young v. Hawaii. There, the Ninth Circuit Court of Appeals held that the Second Amendment does not provide a right to openly carry a firearm for self-defense. That was a 2021 decision, Ninth Circuit, which was prior to the 2022 decision by the U.S. Supreme Court, Bruen. And then they have the citation here, Young v. Hawaii, Ninth Circuit, 2021, judgment vacated and abrogated by Bruen in 2022. So they're citing law they know is invalid. In July 2022, Wilson filed a second motion to dismiss counts 1 and 2. Bruen had just come out. Wilson again challenged the constitutionality of Hawaii's gun control laws. His motion declares he carried the gun solely for self-defense purposes. He says the place to keep laws violate his right to carry a handgun for self-defense outside his home. Both the United States and Hawaii constitutions confer that right, the defendant claims. Wilson maintains that Hawaii's gun control laws, which confine firearms and ammunition to the possessor's place of business, residence, or sojourn, had no exceptions for carrying firearms outside the home. Wilson describes these absolute restrictions as out of step with the nation's historical tradition of firearm regulation. What is the nation's historical tradition of firearms regulation? Is it that you were prohibited from carrying guns in public for self-defense purposes? No. The Maui Department of the Prosecuting Attorney countered. First, they say, the state, the Second Amendment allows for some restrictions per Heller and Bruen, For instance, registration and permitting are constitutional. Bruen did not say that. Second, unlike the Bruen plaintiffs, Wilson illegally possessed a handgun because he never tried to follow Hawaii's firearm registration and license to carry law. Because he didn't apply for a permit, he lacked standing to raise a Second Amendment challenge. You see the circular argument here, folks? We're going to constitutionally infringe your rights. And then if you don't follow our unconstitutional procedures, we're going to say you've lost standing now to assert that constitutional right. It's crazy. Circuit Court, trial court, Judge Kirsten Hammond granted Wilson's second motion to dismiss in August 2022, agreeing that Hawaii's gun control laws infringed Wilson's constitutional right to keep and bear a firearm for self-defense. The court ruled that Wilson had standing to challenge those laws. Then it concluded that per Bruen, a right to keep and bear arms for self-defense under the Hawaii and United States Constitution extends outside the home. The state had failed to meet its burden to show that Hawaii's gun control laws are consistent with the nation's historical tradition of firearm regulation. Well, obviously. By the way, the nation means America, the United States. It does not mean pre-state Hawaii. The founding fathers were not envisioning pre-state Hawaii when they drafted the Constitution of the United States and ratified it. That was not their understanding of the Second Amendment, that it was a Second Amendment so long as it was consistent with Hawaii's, at the time, run by monarchs and savages, cannibals, idea of weapons possession. The circuit court also found that the gun control laws made no exceptions for carrying firearms outside the home for self-defense purposes. And then it notes there are exceptions in those laws. This mistake, though, is immaterial to our decision. The trial court dismissed counts 1 and 2 with prejudice. The state moves to reconsider. Then the Department of the Attorney General got involved. The court granted its request to file an amicus brief in support of the Maui prosecuting attorney's motion. The Attorney General argued that Bruen does not stop states from requiring a license before bringing a firearm to a public place. The trial court denied the motion to reconsider. By the way, Bruen does not address this issue. In fact, Bruen actually says, we're not addressing licensing schemes now, but we recognize that licensing schemes are subject to abuse. And to the extent they become abusive, to the extent they make it practically impossible to exercise a Second Amendment right, they will be unconstitutional. And I would suggest a licensing scheme in which Maui has never issued a concealed carry permit is exactly an example of that kind of abusive regulatory scheme on a Second Amendment right. So the trial court denied the motion to reconsider. The state appealed, then it filed an application for transfer to the Hawaii Supreme Court from a local trial court, and we granted the transfer. Subsection 3. We hold that the text and purpose of the Hawaii Constitution and Hawaii's historical tradition of firearm regulation do not support a constitutional right to carry deadly weapons in public, which is all irrelevant because the right is a federal right that the U.S. Supreme Court has said applies to all the states, regardless of an individual state's perception or history or tradition of keeping and bearing arms. The Hawaii Supreme Court here is just having a hissy fit, basically. They're like children talking back to their parents. You're not the boss of me. You're not the boss of me. Actually, yeah. The U.S. Supreme Court is the boss of you when it comes to federal constitutional rights that all Americans possess, that are not lost simply because you cross the state border. The Hawaii Supreme Court continues. We conclude that Hawaii's gun control laws do not violate Wilson's right to keep and bear arms under the Article 1, Section 17 of the Hawaii Constitution and the Second Amendment to the U.S. Constitution. Since Wilson lacks standing to challenge the permitting process, that's circular argument again, we do not take up his Second Amendment challenge to that law. Standing, I'm going to skip over the standing issues. We've already referenced it, and it's all legalese in the interest of time. Let's see. Our sequence of state constitutional interpretation, Wilson invokes both the Hawaii and United States constitutions. You may have heard of something called the Supremacy Clause, folks. The U.S. Constitution is supreme over the constitutions of the individual states. So if you have a right under the U.S. Constitution, it doesn't matter what the state constitution says. This court has yet to explain how we interpret matching state and federal constitutional provisions when both are in play. As I just said, folks, when both are in play, the federal is supreme. Do we look at the state constitution first? The federal constitution first? Both? If we interpret our constitution to provide more protection, do we even take up the federal constitution? More protection for whom? Court, the state, or the defendant? We believe that the proper sequence to consider matching constitutional text is to interpret the Hawaii Constitution before its federal counterpart. Only if the Hawaii Constitution does not reach the minimum protection provided by a parallel federal constitutional right should this court construe the federal analog. Again, they don't say who's being protected here. And this is exactly the reverse. The proper analysis would be, does the federal provision grant a right? If it does, it doesn't matter what Hawaii says. Kostas notes, they look at the Hawaii Constitution first, but it's the same thing. And then he quotes the Hawaii Constitution. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Article 1, Section 17 of the Hawaii Constitution, enacted in 1959. Back to the decision now. Thus, we interpret the Hawaii Constitution first and may not get to the United States Constitution. Let's see. The Hawaii Constitution often offers greater protections than the federal Constitution. When the two contain look-alike provisions, Hawaii has chosen not to lockstep with the Supreme Court's interpretation of the federal Constitution. Again, they're not saying who's being protected. So I would agree that if, say, for example, the federal Constitution says the police need a warrant to enter your home, but they don't need a warrant to search your garbage can out at the curb. And the Hawaii Constitution says, no, we think the citizen is more protected than that. We think the police also need a warrant to search the garbage can. In that sense, when the Hawaii Constitution is granting greater rights and privileges to a citizen, that's fine. But that's not what's happening here. The reverse is happening here. And when the reverse is the federal government grants greater, more expansive rights and privileges to a citizen, and the Hawaii Constitution grants less, it's the federal Constitution that controls. You needn't even look at the state constitution. Hawaii doesn't get to pick and choose when it gives American citizens lesser rights under the U.S. federal Constitution. Continuing now with the decision. Rather, this court frequently walks another way. They walk a different way. They have their own path. They march to the beat of a different drummer than the U.S. Supreme Court. Long ago, the Hawaii Supreme Court announced that an opinion of the United States Supreme Court is merely another source of authority, admittedly to be afforded respectful consideration, but which we are free to accept or reject in establishing the outer limits of a protection afforded by the Hawaii Constitution. But we're not looking at the outer limits. We're looking at the inner limits. Here, Hawaiian law is more restrictive, not more expansive, not the outer limits of a right or privilege. Continuing. Further, this court has not hesitated to adopt the dissents in U.S. Supreme Court cases when it was believed the dissent was better reasoned than the majority opinion. This is shocking to me, an American lawyer, that when Hawaii, the state of Hawaii, doesn't like a controlling U.S. Supreme Court decision, they can pretend it doesn't exist and instead choose the non-precedential dissent from an opinion if they like that better. That is not how American law works, folks. Interpreting the Hawaii Constitution is this court's number one responsibility. So we reason independently, untethered from the Supreme Court's analysis of the United States Constitution. This is insurrection, folks. The Hawaii Supreme Court is in rebellion against the U.S. Constitution. It's called the U.S. Supreme Court for a reason. Hawaii's people are entitled to an independent interpretation of state constitutional guarantees, but we're not talking about state constitutional guarantees, or we ought not be. This means this court, not the U.S. Supreme Court, drives interpretation of the Hawaii Constitution. Well, no, but in any case, it doesn't matter because what's under discussion is the federal Constitution. They're pretending that the Hawaii Constitution has authority, supremacy over the U.S. Constitution. Back to the decision. If we ignore this duty, we fail to live up to our oath to defend Hawaii's Constitution. You took an oath to the U.S. Constitution. State constitutions have a distinct role under our nation's system of federalism. Deciding a case first on state constitutional grounds respects state sovereignty and aligns with a key constitutional design feature, subnational governance. So, folks, the U.S. Constitution has something called the Supremacy Clause, where the feds and the states are addressing an identical issue. The federal law controls, not the state law. As the Oregon Supreme Court put it, the proper sequence is to analyze the state's law, including its constitutional law, before reaching a federal constitutional claim. This is required not for the sake either of parochialism or of style, but because the state does not deny any right claimed under the federal Constitution when the claim before the court, in fact, is fully met by state law. Again, they're doing it absolutely backwards here, folks. If the state allocation allowance was broader than federal law, this would be true. The state constitution can grant broader rights than under the federal government, but it cannot constrain rights under the federal Constitution. Continuing with the decision, the state constitution first approach recognizes the states are the cradle of rights. State constitutions predated the Constitution as the original sources of constitutional rights. And then when the Constitution was ratified, the states agreed it was supreme. The Bill of Rights cut and pasted rights first ensconced in pre-1789 state constitutions. And for more than a century, state constitutional rights were the only rights enforceable against state governments. Yes, until the Civil War. You know that thing, the Civil War? And then the 13th, 14th, and 15th Amendments to the U.S. Constitution that apply the Bill of Rights to the states by incorporation. And look at this case they cite, Gitlow versus New York, 1925, incorporating the Bill of Rights against subnational actors, in other words, the states. It doesn't matter what the law was before 1865. It matters what the law is today. State constitutions provide a double security for the people's liberty. Per the Constitution's design, the Hawaii Constitution supplies an additional guarantee of individual rights. Does it? It looks to me like it constrains individual rights. But federalism is about more than just the relationship between state and federal governments. We must not forget that the virtue of federalism lies not in the means of permitting state experimentation, but in the ends of expanded liberty, equality, and human dignity. How do gun control laws expand liberty exactly? We honor the Hawaii Constitution's freestanding vitality. What does that mean? We interpret the Hawaii Constitution first. Wilson's constitutional claims. Wilson, the defendant, argues that Hawaii's gun control laws violate his putative right to keep and bear arms under Article 1, Section 17 of the Hawaii Constitution and the Second Amendment's brand new right to bear arms in public for self-defense. See, they really hate Bruen, right? Oh, that shouldn't have like the normal authority that a Supreme Court decision has because it's brand new. It's brand new. I wonder how they felt about Roe v. Wade when that was brand new. Hawaii's gun control laws criminalize the carrying of a loaded pistol or revolver and ammunition. Hawaii gun control law permits the licensed carry of firearms outside the home, but Maui had never issued a concealed carry license, ever, in 70 years of being a state. Thus, Hawaii's gun control laws regulate firearm use by restricting the right to publicly carry a handgun and ammunition for self-defense purposes to those who apply for and receive a carry license. No one had ever received a carry license in Maui. The entire state of Hawaii had only issued 4 in 70 years. You wonder why people weren't applying? Wilson, the defendant, possessed an unlicensed, concealed, and loaded handgun to, he says, protect himself. Only certain factual circumstances justify shooting another human in Hawaii. Well, and everywhere else. But he didn't shoot anybody. The use of deadly force is justifiable if the actor believes that deadly force is necessary to protect themselves against death, serious bodily injury, kidnapping, rape, or forcible sodomy. Very normal self-defense law. The state argues Wilson handgun toting conduct is not saved by the right to bear arms. He trespassed, a crime. He's not law-abiding. The state's position makes sense in the abstract. Neither Bruen nor any case protect the right to commit a crime while armed. Well, you don't have a right to commit a crime, whether you're armed or not. That's why it's called a crime. The state's argument about Wilson's alleged criminal conduct does not apply. Wilson's criminal trespass charge is not before this court, and it's a trial matter. So all the people defending this position by saying Wilson falls outside the scope of Bruen because he was trespassing at the time, even the Hawaii Supreme Court's not claiming that. That's not part of this decision. That is not their rationale for denying Wilson the constitutional rights that Bruen says he has. The parties dispute the facts and declarations attached to their motion to dismiss briefing. These declarations are fair game for now. They comply with Hawaii rules of penal procedure. Wilson denies trespassing. So it's not a fact. It has not yet been proven beyond a reasonable doubt. Wilson says that he and his friends were hiking that night to look at the moon and native Hawaiian plants. They did not see any no trespassing signs. For purposes of the motion to dismiss, Wilson's alleged criminal conduct does not prevent him from challenging the charges under the Second Amendment and Hawaii's Article 1, Section 17 of the Hawaii Constitution. So trespass is off the table as an issue. So we go to Wilson's Article 1, Section 17 constitutional challenge. The court eyed Article 1, Section 17 before this court, the Hawaii Supreme Court, in State v. Mendoza. But Mendoza dodged the key question. Does Hawaii's Constitution afford a personal right or a collective right to keep and bear arms? Again, this doesn't matter, folks, because even if Hawaii's Constitution only offered a collective right to keep and bear arms, the Supreme Court of the United States has made clear that the Second Amendment is an individual right, and therefore their broader interpretation of the right to keep and bear arms is controlling on Hawaii as it is on every other state. Mendoza appealed from his conviction for unlawful possession. The law violated his right to bear arms under the state and federal constitutions, he argued. After some textual and historical analysis, by the way, this was all pre-Bruen, pre-everything, pre-Heller, pre-McDonald. After some textual and historical analysis, this court chose not to decide. Quote, "It is unnecessary for us to decide whether the framers intended to establish an individual or a collective right to bear arms under the Hawaii Constitution. The Mendoza court upheld the firearms regulation, even assuming, without deciding, that Article 1, Section 17 establishes an individual right to bear arms." That question's been answered, folks, by the U.S. Supreme Court. Their Second Amendment is an individual right. Just like everywhere else in the Constitution, when it refers to the people means individual people. When the Constitution wants to refer to a state right, it says state. Justice Levinson concurred. He concluded there was no individual right. Article 1, Section 17 of the Hawaii Constitution covers conduct with a reasonable relationship to the preservation of efficiency of a well-regulated militia. Here we decide the constitutional question previously sidestepped. Because the text of Article 1, Section 17, its purpose, and Hawaii's historical tradition of weapons regulation support a collective militia meaning, we hold that the Hawaii Constitution does not afford a right to carry firearms in public places for self-defense. So I think the court here is wrong in its analysis because it's applying pre-1950 Hawaiian history. That's not American history, which is what Bruen requires in the analysis. But in any case, it doesn't matter. Even if there was applicable Hawaiian history that favored a militia reading of Hawaii's version of the Second Amendment, that doesn't change the U.S. Supreme Court's interpretation of the federal Second Amendment as an individual right. Article 1, Section 17 of the Hawaiian Constitution reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment is nearly identical. Only 2 commas and 3 capital letters separate the two. The Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Since Article 1, Section 17 imitates the Second Amendment, it is helpful to look at what the Second Amendment's words mean. Well, this has already been decided by the U.S. Supreme Court. Hawaii's interpretation of the federal Second Amendment does not supplant the U.S. Supreme Court's interpretation of the Second Amendment. The arrogance of even doing this textual interpretation of the Second Amendment when the Supreme Court has in recent history done all that. A textual approach to constitutional interpretation appreciates that words appear or do not for a reason, like the word people. Both clauses of Article 1, Section 17 and the Second Amendment use military-tinged language, well-regulated militia, and bear arms to limit the use of deadly weapons to a military purpose. That's not what the Supreme Court says. And what does military-tinged mean? What does that mean? Because at the founding, the militia was everybody. And bear arms, people could bear arms at the founding. Normal, law-abiding people. There was no restriction on their bearing of arms for lawful purposes. Military-tinged. In contrast, there are no words that mention a personal right to possess lethal weapons in public places or possible self-defense. You see what they're doing here? Of course, it says the right of the people to keep and bear arms. Right there, the people, individuals, to keep and bear arms shall not be infringed. That means you don't get to limit it to just their home. Already decided by the U.S. Supreme Court. Kostas here notes, Hawaii Supreme Court rehashes tired collective right arguments, which the Supreme Court has expressly rejected, and overwhelming amounts of historical evidence confirm to be false. And if you go to Kostas's Twitter account, @MorosKostas, MorosKostas, he's got a pinned tweet there with tons of contemporaneous historical evidence of the individual right to keep and bear arms. Back to the decision. First, we examine the prefatory clause to Article 1, Section 17 and the Second Amendment. The opening words carry a military meaning. The well-regulated militia clause warms up the rest, defining the text. It sets forth the object of the amendment and informs the meaning of the remainder of its text. They're quoting here, folks, from the U.S. Supreme Court decision of Heller. They're quoting from the failed dissent, the dissent of then Justice Stevens, the wrong side of Heller. Really contemptible. Article 1, Section 17's first clause offers context and clarity, like preambles do. It cannot be presumed that any clause in the Constitution is intended to be without effect. Now they're quoting Marbury versus Madison, which is the very first U.S. Supreme Court decision in which the Supreme Court essentially grabbed for itself the authority to determine whether or not something was constitutional or not. The federal Constitution deploys militia to mean an irregular state military force that may be called up by the federal government to combat outside invasions or internal insurrections. That's not what the militia meant at the founding. They're citing here a decision from 2002. At the founding, the militia was everybody, frequently called up just by the states or by local authorities, not solely called up by the federal government to combat outside invasions or internal insurrections. Article 1, Section 8 gives Congress power to provide for calling forth the militia, to execute the laws of the Union, suppress insurrections, and repel invasions, and to provide for organizing, arming, and disciplining the militia. Yes, but not only Congress. Congress had that power, so did the individual states. U.S. Constitution, okay. Article 2 makes the President of the United States the Commander-in-Chief of the Army and Navy and of the militia of the several states when called into the actual service of the United States. But when not called into the actual service of the United States, it's not like the state militias didn't exist. They still existed. They just weren't under the authority of the President when they were not being called into the actual service of the United States. Founding-era dictionaries agree. A bunch of nonsense. To English speakers in 1791, 1868, and now, the first clause narrows the right that the second clause confers. It is the people who make up the militia that need to keep and bear arms to protect the free state. And here we have a note from Kostas. Nonsense. If it meant just people in a militia, it would have said that. Like everywhere else in the Constitution, the people is mentioned. We are talking about individual rights or protections. Back to the decision. Centuries ago, the right to keep and bear arms was not universal. It wasn't for all. Centuries ago. The people who had the right to keep and bear arms included a discrete subset, one that excluded people based on gender and race. Oh, so sexist and racist laws should be guiding U.S. constitutional rights in 2024? Is that what you're telling us, Hawaii? Only able-bodied freemen could join a militia. Article 1, Section 17, second clause also carries an obvious purpose, citing United States v. Miller. This is a U.S. Supreme Court that was favored gun control. In 1939, it's a decision where the defendant did not show up to court. So, of course, the state won. And by the way, a U.S. Supreme Court decision from 1939 that's in conflict with the U.S. Supreme Court decision in 2024, not to mention Heller and McDonald and Caetano, that's not controlling law anymore. The term bear arms, quoting from Miller, is a familiar idiom. When used unadorned by any additional words, its meaning is to serve as a soldier, do military service, fight. Again, they're quoting from Heller, the dissent in Heller. The non-authoritative portion of Heller. The arguments in Heller that failed is what this court is citing. Bear arms is to serve as a soldier, quoting Webster's New International Dictionary from 1960. Is 1960 contemporaneous with the founding? No. Another tweet here from Kostas. Justice Scalia debunked this position in Heller. Scalia wrote the majority, the actual authoritative portion of Heller. Bearing arms means military service, sure, but to keep and bear arms would make no sense if it was referring to just military service. Like Scalia said, it would be like interpreting he stood up and kicked the bucket to mean he stood up and died. Back to the opinion. Before Article Section 17, bear arms had the same meaning, going way back before Hawaii was a state. Some textualists champion corpus linguistics, an analysis of how particular combination of words are used in a vast database of English prose. They see it as an important tool in figuring out the meaning of a term. Like the first causes, by the way, and now they're citing a court opinion, a concurring opinion from a federal circuit court case. A concurring opinion is not controlling, folks. So you have the majority opinion of a court, and then a judge, a justice can write some additional comments of his own in a concurring opinion. They're not authoritative unless they reflect the actual majority opinion. So this is as bad as citing a dissent. Like the first clause's well-regulated militia, the second clause's bear arms has a collective military meaning. This is all done away with by the use of the word people. It could have said the right of the militia to keep and bear arms shall not be infringed, right? The founders knew the difference between people and militia. Linguistic experts have churned through historical materials like the corpus of founding era American English and the corpus of early modern English to get to the bottom of the Second Amendment's key words. So we don't need this weird, whatever this is, AI linguistics analysis, because we have the writings of the founders, contemporaneous writings of founders and legal experts at the time of the founding. Founding era sources almost always use bear arms in an unambiguously military sense. I mean, again, go to Kostas's Twitter account and look at that pinned tweet and see all the contemporaneous founding era historical evidence of an individual right. I'm going to skip some of this because it's such clearly nonsense. See, judges interpret words as part of the job, but judges are not language and speech specialists. Before Bruen, linguists informed the Supreme Court about their research. Corpus linguistics researchers have unearthed a wealth of new evidence over the past decade showing that the phrase keep and bear arms overwhelmingly had a collective militaristic meaning at the founding. So these are supposed experts, academics, who are all anti-gun. They're paid for by Bloomberg. They're paid for by the anti-gun factions. So of course that's their position. And they had the opportunity to present this argument to the U.S. Supreme Court. They did present it before Bruen. And what did Bruen decide? We disagree with you. This is an individual right. So all this supposed linguistic expertise is legally irrelevant. The Supreme Court looked at it, considered it, rejected it. It is not law. No words in Article 1, Section 17 in the Second Amendment describes an individual right. Well, except for the words the people. No words mention self-defense. Well, it mentions the broad right to keep and bear arms, which we know from contemporaneous writings was in large part for self-defense. Bear arms, reads the text. The unmodified use of bear arms refers most naturally to a military purpose as evidenced by its use in literally dozens of contemporaneous texts. The absence of any reference to civilian uses of weapons tailors the text of the amendments to the purposes identified in its preamble. Again, this court is citing from the dissent in Heller. The dissent, the failed argument. That is not law. The Hawaii Constitution leaves out an individual right to bear arms. Our framers had options. They could have worded the Constitution to plainly secure an individual right to possess deadly weapons for self-defense. They didn't. They didn't? How about the right of the people to keep and bear arms shall not be infringed? That didn't do that? The Pennsylvania Constitution of 1776 did. The people have a right to bear arms for the defense of themselves and the state. The Vermont Constitution, too. The people have a right to bear arms for the defense of themselves and the state. Well, the federal Constitution is broader. The right's not limited to defense of yourself and the state. You have the right for all lawful purposes. Hunting, competition, fun. Kostas writes, this is hilarious because the Hawaii Constitution was adopted in the 1950s. If the court is correct and it's just some militia right, why would that still be relevant by the mid-20th century with our massive standing army? Why did Hawaii bother adding its version of the Second Amendment at all? We had just won World War II, folks. Continuing with the decision. The Hawaiian Constitution and 44 state constitutions identify a right to bear arms. 2 states amended their constitutions post-1996, Wisconsin and Iowa. 5 states, California, Maryland, Minnesota, New Jersey, and New York, do not have a Second Amendment counterpart in their constitution. And besides Hawaii, only 4 state constitutions, Alaska, North Carolina, South Carolina, and Virginia, still say well-regulated militia. Unlike Article 1, Section 17 of the Hawaii Constitution, nearly all state constitutions that recognize a right to keep and bear arms expressly identify it as a civilian right for personal self-defense. Overwhelmingly, state constitutions use individual-centric language. Like the people? They recognize a right to bear arms for any person or every citizen. Quotes here from some different state constitutions. We believe that if Article 1, Section 17 meant to provide an individual right to carry deadly weapons in public for self-defense, then it would say so. But it doesn't matter what the Hawaii Constitution says. If the federal provision of the Second Amendment is broader, it's controlling. Hawaii does not get to infringe a federal constitutional right. Until Heller, the Hawaii Supreme Court writes, the U.S. Supreme Court had never ruled that the Second Amendment afforded an individual right to keep and bear arms. Right. But then we had Heller. It's like saying, before a married couple had their first child, they had no need for diapers. Okay, so now they've had the child. Now they do have a need for diapers. What the hell is wrong with the Hawaiian Supreme Court? Because the Second Amendment provided a collective right before Heller, now we're post-Heller, most states conferred an individual right through their constitutions. Federalism principles allow states to provide broader constitutional protection to their people than the federal constitution. Yes, that's true. That's not what Hawaii is doing here. It's providing lesser constitutional protection than the federal constitution. In any case, Kostas notes, this is not true. The individual right was implicitly confirmed in Dred Scott and Cruikshank. These are terrible rulings for other reasons, but they both confirm in passing the thinking around Second Amendment at the time, an individual right, albeit one that only limited the federal government until after the 14th Amendment incorporation to the states. Continuing with the decision, Hawaii chose to use civic-minded language. Civic-minded. Article 1, Section 17 textually cements the right to bear arms to a well-regulated militia. Its words confer a right to keep and bear arms only in the context of a well-regulated militia. Those words do not support a right to possess lethal weapons in public for possible self-defense. Again, it doesn't matter what Hawaii allows. It matters what the federal constitution allows. Subsection 4, the original public purpose of Hawaii's Article 1, Section 17 and the Second Amendment also supports a collective military interpretation. So now the Hawaiian Supreme Court is interpreting the Second Amendment in a manner substantively different than the U.S. Supreme Court and saying the Hawaiian Supreme Court's interpretation of the Second Amendment trumps that of the U.S. Supreme Court. This court construes the Hawaii Constitution with due regard to the intent of the framers and the people adopting it, and the fundamental principle in interpreting a constitutional provision is to give effect to that intent at the time. We conclude that the authors and ratifiers of the Hawaii Constitution imagined a collective right. Our understanding aligns with what the Second Amendment meant in 1950, when Hawaii copied the federal Constitution's language, and in 1968 and 1978, when Hawaii's people kept those words. But what the U.S. Constitution means, what the Second Amendment means today, is determined by the U.S. Supreme Court today, not the U.S. Supreme Court in 1950. Proceedings of the Constitutional Convention of Hawaii of 1950. Let's see. Legislative history shows that the first framers of the Hawaii Constitution had concern about the potential impact that a bear arms provision would have on existing firearms registration laws and the state's ability to pass reasonable laws. The committee reports disclosed the framers' intent to allow sensible firearms legislation. Sensible is not a legal term of art, folks. That just means emotionally. How do we feel about it in the moment? That's inapplicable to an enumerated constitutional right. Kostas writes, do you think they even realize that their legislative history excerpt destroys their own argument? If the Hawaii framers were intending a collective right, they wouldn't be talking about reasonable restrictions on the right of the people. They'd say they can pass anything they want, as this is just about the right to a state militia. Section 15 incorporates the Second Amendment of the federal Constitution. In adopting this language, it was the intention of the committee that the language should not be construed as to prevent the state legislature from passing legislation imposing reasonable restrictions upon the right of the people to keep and bear arms. Again, this reasonable is an emotional word. The 1950 Constitutional Convention delegates expressed an intent to preserve the territory's firearms regulations. They had foresight, too, reserving the right to later pass laws to ban modern and excessively lethal weapons, which is irrelevant here. This section, now quoting, I guess, from the legislative history, this section incorporates the Second Amendment to the Constitution. Your committee wishes to make it clear that this section will not render invalid the existing laws of the territory, which will be continued in effect by the state constitution relating to the registration, possession, and carrying of firearms, nor will it prevent the legislature from passing other reasonable restrictions on the right to acquire, keep, or bear firearms or other weapons, including the power of the legislature to entirely prohibit the possession of such modern and excessively lethal weapons as machine guns, silencers, bombs, atomic weapons, etc. Upon this understanding, your committee recommends the adoption of this section. None of this means anything. Even if this is all true, and in 1950, this was the intent of the Hawaiian legislature in adopting the Hawaiian Constitution, it's still not allowed to be in conflict with the U.S. federal Constitution. It's not allowed for a state to infringe your federal constitutional rights, no matter how much you want to. Kostas writes, same thing here. This literally says the right to acquire, keep, or bear arms. Yes, maybe the 1950s Hawaii legislature had a muscular view of what gun control was allowed, including banning certain guns, but they still presuppose some individual right. It is the Hawaii Supreme Court's reading comprehension that is non-existent. Back to the opinion. And folks, this is taking much longer than I thought. So we're not going to get through this whole thing today. This is going to be a part 1, part 2 show. Sorry about that. But I'll lose my voice if I try to talk for another full hour today. I'll get to the next major section, another page or two, and then we'll have to wrap up today's show, and we'll conclude tomorrow. The 1968 Constitutional Convention endorsed the Hawaii Constitution's text and original purpose. The introduction to a series of legislative reference bureau studies prepared to aid the convention's delegates explains that Article 1, Section 17 was based on the conventional and traditional interpretation of the Second Amendment. The historical background of the Second Amendment indicates that the central concern in the right to bear arms was the right of the states to maintain a militia. The 1968 Constitutional Convention Standing Committee recommended retaining then Section 15. The committee's report clarified, quote, the committee feels that reference must be made to the report of the 1950 Constitutional Convention in order that the people of the state not misconstrue the intent of this section. The right to bear arms refers explicitly to the militia and is subject to lawful regulation. Kostas. Oh, sure. Clarified 18 years later in a way that is completely incompatible with what the legislature of 1950 said. Here, they say it's all about the militia, whereas in the excerpts from the 1950 that the court cited, there was no discussion of the militia, just an individual right, albeit one subject to regulations. What actually happened here is Hawaii politicians adopted the then ascendant military right lie. Back to the decision. 10 years later, the 1978 Constitutional Convention studies similarly advised the delegates. The right to keep and bear arms is one enjoyed collectively by members of a state militia rather than an individual right. This is 1978. Under Bruen, this has no relevance if it conflicts with founding era historical tradition, which obviously it does. The study recounts that the 1968 Constitutional Convention, to clear up any confusion left by its predecessor, confusion. 1950 refers to an individual right, doesn't mention militias. 1968 refers to militias. But that wasn't when the Hawaii Constitution was adopted. The 1968 Constitutional Convention, to clear up any confusion left by its predecessor, stressed that Section 15 referred only to collective right to bear arms as a member of the state militia, but did not amend Section 15. Why not? They could have amended it to take out the people and put in the militia. The Hawaii Constitution's first framers knew about the U.S. Supreme Court's decision in Miller, 1939. To the extent it conflicts with Heller, McDonald, and Bruen, it's not valid law anymore. In 1950, at the Prepare for Statehood Constitutional Convention, only 11 years had passed since the unanimous decision of Miller. Again, that's a case where the defendant didn't show up to court. There, the Supreme Court concluded that the Second Amendment's purpose was to preserve an effective state militia. Quoting Miller, in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Close quote. Look at how limited even Miller is. They're not saying there was evidence. They're saying in the absence of evidence. And they're not saying we can say the Second Amendment does not guarantee a right to keep and bear this arm. They're saying we cannot say that it does guarantee the right. It's completely ambiguous and wishy-washy, which is what you would expect from a decision based on a non-adversarial process where the defendant didn't show up. When the Hawaii Constitution was first ratified, courts throughout the nation's history had always interpreted and applied the Second Amendment with the military-centric view expressed in Miller. This is an outright lie. It's an outright lie. We know from the historical writings at the time of the founding that it was perceived as an individual right. It's only when we get past World War II into the 20th century where we have the Valentine's Day Massacre that we start getting this drumbeat of gun control. It's only later in America's history that we had this militia rights interpretation of the Second Amendment, not at the founding. This is all well documented in Bruen. Read Bruen. Go to lawselfdefense.com/Bruen, Bruen, and see my video and read the decision. They cover all this in determining that there's an individual right to keep and bear arms. Heller, McDonald, Caetano, Bruen. Kostas writes, whoa, what? This is an outright lie. Even if you argue stuff like Dred Scott and Cruikshank are dicta because they only mention Second Amendment in passing, there were several 19th century state court rulings confirming to various degrees the individual right. Back to the decision. This is what everyone thought, according to the Hawaiian Supreme Court, that the Second Amendment was for militias only. A 1969 Law Dictionary explained the right to bear arms refers to the militia, not a constitutional right to carry weapons on one's person as a civilian. A 1969 dictionary, when we're in the midst of gun control era, is not relevant to what the understanding of the Second Amendment was at the founding and when the 13th, 14th, and 15th Amendments were adopted following the Civil War. All of them clearly refer to an individual right to bear arms, especially after the Civil War, when the Democrats in the South were making such tremendous efforts to deny freed slaves arms. It was clear that freed slaves were permitted to bear arms, keep and bear arms under the Second Amendment. Kostas writes, Jesus Christ, the arrogance here is off the charts. This is what everyone thought. No. It's what a cabal of hack academics and their well-to-do judicial allies gaslit the nation into believing for a few decades. The Hawaii Supreme Court basically pretends all the 19th century rulings and commentary do not exist. Their example of courts always ruled this way was two rulings from the 1940s. Continuing with the decision. State and federal courts had also, with few exceptions, upheld laws regulating firearms use and possession. That doesn't make those constitutional. The introductory militia language reveals Article 1, Section 17's purpose: preserve the militia to safeguard the security of Hawaii as a free state. Like Article 1, Section 17, the Second Amendment's original purpose protects a state's right to have a militia. The framers included the right to keep and bear arms in the federal Constitution in response to their fear that the government might disarm the militia, not restrict the common law of the right to self-defense. Are they citing a contemporaneous record from the founding here? No. They're quoting gun control activists from 2004. Contemptible. Madison's writings suggest that the Second Amendment originated from fear of a federal government power grab. Are you going to share those writings with us? Hawaii Supreme Court? Or you're just going to make that claim? The Second Amendment quelled alarm that the national government might disarm and disband state militias. Those militias could oppose a federal army, Madison wrote, and would be able to repel the danger of the federal government. And of course, that was one purpose of the militia. The states had their own sovereignty. They'd always been individual states. Now that they were joining the United States, they wanted to make sure that they weren't subjugating themselves to some larger military force. But that wasn't the only reason people needed guns. Kostas Moros, Saul Cornell site, but because, of course, he's a famous anti-gun academic hack. And also cool how they cite Federalist number 46, written by Madison, but omit the sentence which reads, quote, besides the advantage of being armed, which the Americans possess over the people of almost every other nation, close quote. Do they think Madison meant that the advantage spoken of there of being armed was the right to serve in a government militia? Because people in other nations definitely had that right too. The decision. That's what they were thinking about long ago, a militia purpose, not someone packing a musket to the wig maker just in case. To the wig maker. Until recently, the Second Amendment conferred a collective right to bear arms in service to the militia. And again, they're citing Miller from 1939, a case in which the defendant never showed up. And of course, that is one purpose of the Second Amendment. A well-regulated, meaning well-functioning militia, in the eyes of the founder, required a populace familiar with arms. But it wasn't the only rationale for the right to keep and bear arms. The opinion continues, there was no individual federal constitutional right to carry deadly weapons in public places for self-defense. There were only statutory, common law, or state constitutional rights. Well, the U.S. Supreme Court disagrees with you, Hawaii, and their opinion is controlling. Around Miller's time, this is that 1939 decision where Miller, the defendant, didn't show up. The state militia was evolving into the National Guard. A 1903 act created the National Guard. Then the National Defense Act of 1916 federalized the National Guard, going into World War I, of course. Never let a crisis go to waste. Kostas writes, okay, so again, if all this militia stuff is true, and the Second Amendment is just about militias, what goal was the 1950 legislature trying to accomplish by copying it into the Hawaii Constitution? What was the point of doing that at a time when the state militias didn't really exist anymore? The opinion. The authors of the Hawaii Constitution understood the meaning of militia. Militia meant a body of citizens enrolled as a regular military force for periodical instruction, discipline, and drill, but not called into active service except in emergencies. By then, it included the National Guard. At the 1968 Constitutional Convention, by the way, that definition of militia is from, again, a 1960 dictionary. What's the definition of militia that would control in the constitutional context? The understanding of the militia at the time the Constitution was ratified. At the 1968 Constitutional Convention, Delegate Leland Larson explained, Section 15, the so-called right to bear arms provision, does not refer to the individual's right. It refers to the militia, to the National Guard. Again, this is irrelevant. This is 1968. It's 18 years after the adoption of the Hawaii Constitution. So it would have been the understanding in 1950 that controlled. And in any case, it's an infringement on the U.S. Supreme Court's scope of the Second Amendment. And therefore, it's legally irrelevant. Kostas writes, it's hilarious. They keep saying what the 1950 Hawaii legislature meant through what the legislature 18 years later said. Because the two times they actually cited the 1950 framers, they were clearly talking about an individual right. Back to the opinion. Soon, interest groups advanced an individual rights interpretation of the Second Amendment. Former Chief Justice Burger called out that movement. So he wasn't even the Chief Justice when he made this comment. Quote, one of the greatest pieces of fraud, I repeat the word fraud, on the American public by special interest groups that I've ever seen in my lifetime. The real purpose of the Second Amendment was to ensure that state armies, the militia, would be maintained for the defense of the state. The very language of the Second Amendment refutes any argument that it was intended to guarantee every citizen an unfettered right to keep any kind of weapon he or she desires. Quoting Warren Burger in 1990. When was Burger off the court? see if they can tell us. 1986, he was off the court. So he was no longer Chief Justice at the time he made the statement. Even if he were Chief Justice, and even if this was not merely a comment at some kind of gathering, but was part of a U.S. Supreme Court decision with precedential value, it's been reversed by Heller, McDonald, Caetano, and Bruen. So it's no longer controlling. So why are they even quoting this? Not only would it have been reversed if it was an opinion, it's not an opinion. He wasn't a justice on the Supreme Court when he made this statement. Contemptible. Kostas Moros writes, Warren Berger quote, the hackery is unprecedented. This is written by anti-gun Twitter, basically. As my pinned thread demonstrates, Warren Berger was a liar, ignorant, or both. The opinion continues. Circuit courts agreed. There was no individual right, same as it ever was. Then the Supreme Court granted cert in Heller. Heller flipped the nation's textual and historical understanding of the Second Amendment. The majority insisted there was no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms. Well, guess what, Hawaii? That means that's now the law. Not what you would prefer to be the law, but the actual majority decision in Heller. History by historians quickly debunked Heller's history. If history and history alone is what matters, why would the court not now consider Heller in light of these more recently published historical views? And again, now they're citing from the next Supreme Court Second Amendment decision, McDonald, and they're citing Justice Breyer, the dissent, the failed argument. And do historians trump the U.S. Supreme Court? Kostas Moros. Who cares what a majority of historians think? Most of these are activists masquerading as unbiased historians. For example, almost none of them ever seriously discuss the overwhelming amount of 19th century commentary because it obliterates their arguments. They pretend it doesn't exist. Back to the decision. History is prone to misuse. In the Second Amendment cases, the court distorts and cherry picks historical evidence. It shrinks, alters, and discards historical facts that don't fit. And again, they quote from the dissent in Heller and the dissent in Bruen, the failed arguments. Like they get to pick which side of the argument should be authoritative and have precedential value between the majority and the dissent. Bruen unravels durable law, whatever that means. That means the law they like, the gun control law they like. And it does. It unravels your unconstitutional gun control laws. No longer are there levels of scrutiny and public safety balancing tests long used by our nation's courts to evaluate firearms laws. Instead, the court ad-libs a history-only standard. Yeah, that's what Bruen holds. You cannot interest balance infringements of the Second Amendment. The interest balancing was done when the Second Amendment was ratified. Period. In 1791. The Founding Fathers made the call then. No more interest balancing. We did it at the time. The Supreme Court makes state and federal courts use a fuzzy history and traditions test to evaluate laws designed to promote public safety or to evaluate laws that infringe the Second Amendment. It scraps the traditional techniques used by federal and state courts to review laws passed by the people to protect people. Techniques that were applied to the Second Amendment uniquely compared to the other enumerated Bill of Rights. And by turning the test into history and nothing else, it dismantles workable methods to interpret firearms laws. Workable for the state, but not workable for the citizen whose Second Amendment rights are being infringed. All to advance a chosen interpretive modality. Yes, that's what the Supreme Court does. They decide how rights are interpreted. That's their role, and it's authoritative. Yet only a few years before, the court had constrained originalism's liberty-reducing tendencies. The history and tradition of the very old days did not control contemporary American life. This was the Obergefell, the gay marriage ruling. which expanded rights, right? Didn't constrain rights, which of course is the opposite of what's happening here. Judges are not historians. Excavating 18th and 19th century experiences to figure out how old times controlled 21st century life is not a judge's forte. This is really rich, by the way, that they're making this argument that we should just ignore the history at the founding. Judges are incompetent to consider that history, because later in this decision, what do these justices do on the Hawaii Supreme Court? They refer to Hawaii's ancient history. It's way back history, the old times, to justify their gun control laws, even though Hawaii wasn't even a state at the time, was not America. Judges are not historians. We were not trained as historians. We practice law, not history, quoting some decision. Worse, judges may use history to fit their preferred narratives. In addition to the risk that judges will not understand the materials they are charged to consult, judges are incompetent now to rule on law. There is the additional risk that they will not conduct a dispassionate examination of the historical evidence and will simply marshal historical anecdotes to achieve what they have already decided is the preferred outcome. That's exactly what this court is doing here. Exactly. They're citing dissents of opinions. They're citing 1939 Miller decisions where the defendant never showed up because it has the outcome they prefer. Kostas writes, this is another bullshit post-Bruen criticism. Nobody is saying judges have to be historians. They merely have to take historical laws the state presents and see if they are sufficiently similar to modern laws. Analyzing laws is a judge's whole job. I completely concur. History is messy. It's not straightforward or fair. It's not made by most. But we're not talking about history. We're not talking about some subjective form of history. We're looking at actual laws and legal arguments. Bruen, McDonald, Heller, and other cases show how the U.S. Supreme Court handpicks history to make its own rules. A judge's personal values and ideas about the very old days suddenly control the lives of present and future generations. That's right, it does. Kostas writes, we get it, Hawaii Supreme Court. You guys hate the U.S. Supreme Court. This should be the easiest cert petition ever to appeal this to the U.S. Supreme Court. Bruen's command to find an old days analog undercuts the other branch's responsibility at the federal, state, and local levels to preserve public order and solve today's problems, and it downplays human beings' aptitude for technological advancement. Bruen says the legislature can take efforts to solve today's problems, but you can't do it by infringing the citizens' constitutional rights. Maybe catch bad guys and prosecute them and put them in jail. How about that? To secure public order. Time traveling to 1791 or 1868 to collar how a state regulates lethal weapons per the Constitution's democratic design is a dangerous way to look at the federal Constitution. The Constitution is not a suicide pact. We believe it is a misplaced view to think that today's public safety must look like laws passed long ago. What an interesting approach for a state Supreme Court. Because you know what laws we looked at that were passed long ago? How about the U.S. Constitution? The supreme law of our nation, ratified in 1791, or at least the Bill of Rights were 1791, 1787, I think, for the Constitution itself. Are we to ignore that because it's time traveling? Smoothbore, muzzle-loaded, and power and ramrod muskets were not exactly useful to colonial-era mass murderers, and life is a bit different now in a nation with a lot more people stretching to islands in the Pacific Ocean. This is the same ridiculous argument that if applied to the First Amendment, we would only have a constitutional right to quill pens. Make sense? Kostas Moros says, notice how they say 1791 and 1868, which are the periods that the U.S. Supreme Court said is most relevant. 1791, when the Bill of Rights was ratified. 1868, after the Civil War, when the 13th, 14th, and 15th Amendments incorporated the Bill of Rights to the states. Notice how they say 1791 and 1868, but then only talk about guns from 1791. Because if they talked about guns from 1868, their argument would fall apart. By 1868, revolvers had proliferated. Much of the gun crime we see today was possible with the weapons of 1868. So even if you think 1791 shouldn't count because guns were so much more primitive, a lot of that gap was erased by 1868. Regulations like storing powder safely, reporting with guns for militia musters, weapons inspection, and loyalty oaths are hardly helpful to address contemporary gun violence. Yet these odd laws have historical and traditional roots. Well, fair enough, but these were all considered by Bruen. Democratically vetted laws, though, measures taken by today's citizens to save lives, are mostly out of bounds. Well, they're not relevant to the understanding of the Second Amendment when it was ratified. Lethal weapons have little resemblance to weaponry used centuries ago. A well-trained Revolutionary War soldier could fire his Brown Bess musket 3 times a minute. The Civil War's muzzle-loading rifled muskets in the Civil War were an improvement on Revolutionary War weapons, but were still plenty slow and difficult to reload. Of course, by 1868, we had revolvers. Presently, a semi-automatic rifle can fire at least 45 rounds a minute and up to 300 rounds a minute. And again, he's citing here from a dissent. Weapons to maximize death differ from those in the eras Bruen tells us to review. Kostas writes, here they cite Bevis's court's error, at least I hope it wasn't intentional, that a semi-auto AR-15 has a fire rate of 300 rounds per minute, which is 5 rounds per second. Gun use has changed. A backward-looking approach ignores today's realities. We could say this about any of the Bill of Rights, right? In 2019, for every justifiable homicide in the United States involving a gun, guns were used in 30 criminal homicides. But of course, most self-defense uses of guns don't result in a homicide, right? The gun is displayed and the bad guy runs away. So both lives are saved. This ratio does not take into account suicides and fatal unintentional shootings. What's that got to do with the Second Amendment? The United States Supreme Court disables the state's responsibility to protect public safety, reduce gun violence, and safeguard peaceful public movement. All of this is interest balancing nonsense. It's them saying, the gun control is saying, hey, but we have good reasons for infringing your rights. All the U.S. Supreme Court has said, well, good reasons aren't enough. That's not allowed. That's why they're rights. A government by the people works. So a government free of a constitution, I guess. Hawaii's legislative branch has passed sensible firearms laws, and Hawaii's executive branch has enforced those laws. The most recent available data from the Centers for Disease Control shows that Hawaii has the nation's second lowest rate of gun deaths per year. As the world turns, it makes no sense for contemporary society to pledge allegiance to the founding era's culture, realities, laws, and understanding of the Constitution. And here, the Hawaii Supreme Court, in advocating that we dump what the founders intended in the Constitution, we just make it up as we go along. They quote an HBO TV series, The Wire, about drug dealing gangs in Baltimore. Quote, the thing about the old days, they're the old days. I wonder if I saved that. Someone had put up the actual clip. Well, maybe I didn't. That's too bad. That would have been funny. Let me check another bookmark here. That's too bad. I thought I'd saved it. All right. And here Kostas writes, sounds like the Hawaii Supreme Court doesn't even want to be part of the United States in this rejection of not just the Second Amendment, but their culture and understanding of the Constitution. All right, folks. 5, history and tradition in Hawaii. I'm going to pause here because my throat is going. But we will do a part 2. We'll wrap this up tomorrow. Got about 11 pages to go. So it should be a substantially shorter show than the hour and a half I've already done. All right, guys. I'll send that an email to everybody tomorrow. If you're not on our email list, I don't know why. It's easy enough. A great way to do that, by the way, is download our free The 5 Elements of Self-Defense Law cheat sheet. It's just a PDF download, but that'll also put you on our email list for notifications. And what else? I will mention CCW Safe one more time. Learn why they are the self-defense legal services organization that I trust, that I'm personally a member of. My wife is personally a member of. They cover your legal expenses and a lot more if you're involved in a use of force event and you're a member. Learn why I trust them at lawselfdefense.com/trust. I explain it all there. And with that said, I remind all of you that if you carry a gun, so you're hard to kill, so your family is hard to kill. That's why I carry a gun. That's why I carry a knife. That's why I carry pepper spray. That's why I practice jujitsu several times a week, so that I'm hard to kill, so my family is hard to kill. Well, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until tomorrow, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.